That is case number 2024 TO 22, State of Kansas versus Danny Johnson, County Attorney Jill Gillette for the state. Mr. Johnson appearing in person and pro se. Your name tag on your uniform says Johnson, so I presume you are Mr. Johnson. Now, sir, if you could get right in front of that microphone, thank you.
Can you hear me?
I can. Sir,
Yes.
you're charged in count one with speeding 82 miles per hour in a 65 mile per hour zone. That is a traffic infraction. It is not a charge that carries any jail time. It has a scheduled fine. 82 and a 65 is $87, but then there's also 108 court costs. In count two, you're accused of operating your motor vehicle without proof of insurance. Now, if you had insurance but just couldn't find it, you can get the proof to the county attorney and she'll probably dismiss that charge. If, in fact, it had lapsed or something was happening so that you didn't have insurance on the vehicle at the time being January 4th, 2024, that is a B misdemeanor. The maximum penalties as far as jail time would be 6 months, although probation is usually granted. There is a mandatory minimum fine the court must impose of $300, but it could be as high as $1,000. You do have the right to hire any attorney of your choice. If you cannot afford an attorney, you can apply and see if you qualify for court appointed. You can waive your right to counsel and represent yourself. Another option, you might be able to apply for diversion. That is where you apply, and if the county attorney approves you for diversion, you would pay agreed upon fines, costs, get your insurance current, and pay a diversion fee, and she'd dismiss the charges and keep them off your record. If you want to talk about diversion or anything else with your attorney, you certainly will have the opportunity to do that. Your pleas, you have a choice of pleas. You can plead not guilty and we can set this for trial at a later date. You can plead guilty, admitting the charge, and we would proceed with sentencing. Or you could plead no contest, which is neither admitting nor denying the charges, but you'd still most likely be found guilty and we'd proceed to sentencing. If you want to look into diversion, we'll enter a not guilty plea to give you time to do that. You can always change your plea, but once you're convicted, pre-trial diversion is off the table. So
probably not eligible for diversion based on his driving record.
Oh, okay. Well, do you want to talk to an attorney then and discuss whether or not you have a defense? Or?
No, Your Honor, I would like to request a declaratory judgment due to there is no agreement for my performance under any agreement or commission of this.
Watch a self-identified sovereign citizen walk into a Kansas courtroom wearing a United States Army uniform and argue that the laws of the country he swore an oath to defend don't apply to him. That contradiction alone should stop you in your tracks. This isn't just another traffic stop gone wrong. It's a collision between ideology and reality, and the consequences escalate fast. What starts as a routine speeding and insurance case turns into a masterclass in self-sabotage, courtroom defiance, and refusal to accept even the most basic legal framework. The judge here bends over backward to explain rights, options, and exits, diversion, attorneys, even warnings, but every off-ramp is rejected. And as the tension builds, you'll see how sovereign citizen talking points don't just fail, they actively make things worse. The real question isn't whether this ends badly. It's how many chances he's given before it does.
Well, I don't need an agreement from you, sir. So if I were
Well, Your Honor, I simply do not understand the nature and cause of the accusation with regard to the jurisdiction of the venue and nature of this action until the prosecutor properly alleges them there. I cannot enter a plea to the charge until I have the opportunity to raise a meaningful defense on my behalf.
All right, I will then, since you cannot enter a plea today, I will enter a not guilty plea for you and give you
I
time.
object, Your Honor. I object to you entering a plea to me because I must understand the nature and cause of these accusations. So I do not agree to you entering a plea on my behalf.
Well, your position is taken and I'm still going to do it. I will note your objection for the record, but I'm going to enter a not guilty plea.
Well, I object to you entering a plea on
objection
my
is
behalf.
noted. Your objection is noted, and if the time comes, you can appeal that to the Court of Appeals. Now, on the issue
Well,
of
who is,
attorney,
Your Honor, I would like to ask, who bring these charges against me? I should have the right to
all
question.
right, we're not going to have this debate right now. I've told you your charges. I've told you the state of Kansas has filed those through its attorney, Jill Gillette. Now,
Well, I would like to call
I'm
the
going
state to the, I would like to call the state to the stand, Your Honor.
We're not doing that,
State bringing charges against me. Who is it? How did I injure the state?
All right, this is your first appearance. I advise you of your rights. I advise you of your charges and possible.
Your Honor,
penalties.
I object to the proceeding, for I do not know the nature and cause of the
I'm
proceeding.
entering a not guilty plea. Missy, when is
I object to you entering I object to you entering a plea on my behalf. I do not grant you that right.
Missy?
The court date,
You're supposed to act as a trustee.
Sir, you
Now,
need to stop. You're being in contempt of court. You need to stop or I'll have the officer assist you in stopping.
This is the part most defendants would dream of. The judge clearly explains the charges, breaks down the fines, outlines the difference between a traffic infraction and a misdemeanor, and even highlights ways this could quietly disappear from the record. Diversion is mentioned. Proof of insurance could resolve one count entirely. There's no jail exposure on the speeding charge, and even the insurance issue is framed realistically, not punitively. This is the legal system operating exactly how it's supposed to: transparent, patient, and fair. But here's the irony. The more the judge explains, the more Johnson disconnects from reality. Instead of listening for solutions, he's preparing arguments that don't apply to traffic court, criminal procedure, or Kansas law at all. This moment matters because it shows the fork in the road. One path leads to paperwork, fines, and closure. The other leads to conflict, contempt warnings, and escalating consequences. And unfortunately, he's already made his choice.
Your Honor, I would like to also bring to
September
according to USC 12203.
Deputy Miles.
And also
you do,
Article 3, the judge must operate in good behavior. So therefore, if you're making a threat towards me, then
Deputy,
that's
if he's going to
urging
keep
me to
being
perform in your
contentious, I'm going to
court.
have you take him into custody on contempt.
Then that would be illegal search and seizures, Your
Well,
Honor.
wouldn't you need to go back?
It will.
All right,
It's
Missy.
false
I
imprisonment.
want you to stop talking, or you can go upstairs to the county jail. Now, do you want to go to jail tonight?
Your Honor, again, Title
Deputy
4,
Miles, could you
let's
come in and
see.
assist the defendant?
September 27th at 9 o'clock will be the court date.
September 27th, you said 9 o'clock?
Yes.
9 a.m. You must be back here, sir, in person at the courthouse, or you will be arrested for failure to come to court.
Your Honor.
Now, that deputy there is going to take you into custody if you cannot control yourself through the remainder of this hearing.
I'm not doing anything. I'm just enforcing my right, Your Honor.
All right, so your first right is to have a hearing date, and that is September 27th, 9 a.m. The second
Your Honor, I
right,
also have a right to understand the nature
Sir.
of this. I have a right to understand the
All
nature
right.
of cause.
if you don't want to listen to me, you can go to jail. Do you want to hire an attorney or apply for court appointed?
No, I do not. I don't need to hire an attorney, Your Honor.
You want to represent yourself?
I don't need to hire an attorney. I would like for you as the judge, Your Honor, to explain to me the nature and cause of the.
All right, I'm not going to appoint an attorney if you don't want me to. If you want, you said you don't want to hire an attorney. If you want to apply for court appointed, the officers have forms there that you can fill out. If
I
you
just want to
don't fill them
understand the
out,
nature
I'm
and
going-
cause.
If you don't want to fill one out, I'm going to assume you don't want an attorney. And then if you come to court September 27th at 9 a.m., you're going to be representing yourself if you don't hire or apply for court appointed. And so you've got the third issue. Does he have a bond? Looks like you do, because you failed to appear February 27th at your first appearance. So bench warrant was issued, bond was set at $1,000 cash for professional surety. Looks like that was posted. Looks like you made a cash bond of $1,000. Does that sound right? You put up $1,000 cash back in July 12th?
I'm still trying to understand the nature and cause of this allegation, Your Honor.
I will continue your bond unless you get yourself hauled into jail on contempt before you.
Where sovereign citizen ideology fully takes the wheel. Instead of entering a plea or asking for clarification within the legal framework, Johnson starts talking about agreements, performance, and consent, concepts borrowed from internet pseudo-law that have absolutely no relevance in criminal court. Courts do not require personal contracts to exercise jurisdiction. Traffic laws aren't optional terms of service, and the judge's response is key. Participation in public life comes with obligations, not opt-in clauses. This exchange highlights a core misunderstanding shared by sovereign litigants: the belief that refusing to acknowledge authority somehow strips it of power. In reality, it does the opposite. It forces the court to assert authority more firmly. And once a defendant starts rejecting basic procedures like entering a plea, the system doesn't collapse. It moves forward without them.
I will continue your bond with the condition that you reappear here in person at September 27th at 9 a.m. So you've got your court date, you've got your bond, and we've talked about your lawyer. Now, you're wearing a U.S. Army uniform with the name Johnson on it. Are you in or have you been in the United States military?
Your Honor, I'm still trying to understand the nature and cause of the allegation, Your Honor.
All right. If you can leave the courthouse now without any further disruption, I will let you do so. And I'm going to have those officers escort you to make sure you do so. So, Ms. Gillette, anything further?
Your Honor, it is your oath to explain the nature and cause of the allegation against me. Are you failing to do that?
All right. You can either walk out the front door with the officers, or you can walk upstairs to the county jail with the officers. The choice is yours. Either leave.
Your Honor, I'm trying to understand.
Or leave disruptively.
I'm not being disruptive. I'm just trying to understand the nature and cause of the charge.
All right, officers. I'm gonna close.
What am I doing? I'm sitting here trying to understand the charge.
If he gives any more grief.
All I'm asking is to understand the charges. This is for the record. You said it's for the record, so I'm trying to understand what am I being charged?
The charges. Goodbye, sir.
I just want to understand the nature and cause of the charges, Your Honor. That's all I ask. It is your oath to give that.
If you tell me what kind of questions you have, I will be happy to answer them. But I've already told you.
Okay. Under what jurisdiction is these charges being brought to me under?
All the
State of
jurisdictions.
Kansas is charging
All
you
of them.
speeding 82 and a 65 and operating in a motor vehicle without liability insurance on January 4th, 2024 in Greenwood County, Kansas. You failed to appear for your first appearance, and a bench warrant was issued, and you were arrested, and you made a bond of $1,000 cash or surety, posting a cash bond. Now you have to go to court, and you have to answer those charges. You can
Your Honor, I
have
know.
a trial if you like, and the burden will be on the state of Kansas to either prove or disprove. If they can't prove it beyond a reasonable doubt, you're let go.
Well, I'm still trying to understand what jurisdiction am I being charged under, Your Honor? That's all I'm trying to understand.
You're being
All the
charged under the
All of
jurisdiction
them.
of the state of Kansas under its criminal.
But according to the Constitution, there are only two
All right,
jurisdictions.
we'll have that on a later date. We'll be in recess, officers. Please escort him one way or the other, depending on his behavior.
But I'm still not understanding what you're charging.
Bye. We are adjourned.
But if she's the judge, I'm supposed to have clear and concise of what I'm being charged with.
The judge just said, you give us any problems with the-
I'm not giving y'all a problem. I'm trying to.
All right, put you in handcuffs.
Well, I'm waiting on the Your Honor to explain.
All right, Missy. We'll
But
be-
that's it.
That's our last case on the docket, isn't it?
This is not good.
Yes.
All right. All right. Ms. Gillette, I'll see you at 3:30 docket.
Your Honor, can I please go home? Your Honor, can I please go home? I'll leave.
All right. Well,
Can I go home?
This moment is critical because it shows how the legal process handles obstruction. When a defendant refuses to enter a plea, the court doesn't stall indefinitely. The judge enters a not guilty plea on their behalf to preserve the defendant's rights and keep the case moving. Johnson objects loudly, but objections don't override procedure. This is where many sovereign citizens believe something improper has happened, when in fact the court is following black-letter law. The judge even explains the appeal process, which undercuts any claim of unfairness. What's really happening here is a loss of control. Johnson wants to dictate the terms, but courts don't operate on personal permission. And the more he resists, the more authority he hands to the judge to manage the proceedings without him.
I'm looking for a Johnson. Do I have a Johnson?
Yes, you do. I am
Danny?
here. Can you hear me?
Yes, but you're not the Johnson I was looking for, but I will take your case up. I have a couple. I have a Danny Johnson, and, well, don't I have her on here? Oh, she's Stasha Carter. Do you go by Johnson also?
Okay, so I'm here for Danny Johnson.
Oh, are you the attorney?
I'm a representative for him.
What does that
And-
mean?
That means I'm his wife, and we sent
Okay, are you an
documentation.
attorney?
I'm an attorney, in fact.
You're not an attorney at law?
No.
Okay. So when
So-
you say
so
you're an
Mr.
attorney, in fact, you're not an attorney, but you're here on his behalf as a citizen. Is that
No,
right?
I'm not a citizen. I'm not a citizen. But
Right.
let me state for the record, Mr. Johnson is under doctor's care. He's in recovery. We sent the documentation over to the courts to show that, to show proof of that. We also reserve our rights to any and all reproduction of or distributing of videos on social media platform.
When the judge warns him to stop or face contempt, this isn't a threat, it's a safeguard. Contempt powers exist to maintain order, not to punish disagreement. But Johnson treats every boundary as hostility and every instruction as tyranny. The foreshadowing here is unmistakable. Repeated interruptions, refusal to stop speaking, and accusations against the court are the fastest route to being taken into custody without resolving a single legal issue. What's striking is that the judge still shows restraint. There's patience, there's warning, there's time to course correct. But sovereign ideology thrives on escalation. Compliance feels like surrender, even when it's clearly in the defendant's best interest.
And we request the matter to be rescheduled at a later time when he can get through his recovery period.
All right, Mr. Johnson failed to appear at his first appearance, February 27, 2024. August 13th, 2024, he appeared. We took formal first appearance. He entered a not guilty plea. Actually, he objected, I think, to just about everything that we did. He was argumentative, disrespectful, interfered with court proceedings. I believe he was
Your Honor. I think he was
Stop.
He was.
You don't have any standing here today, Miss Carter, because you're not his lawyer. You're not him.
I'm not Miss Carter. I'm not Miss Carter.
Then why does your screen say Sasha Carter?
That's what it says, but I'm not Miss Carter, and it says.
Who are you? Who are you? Before I disconnect you from these proceedings, because you don't have standing to be here. What's your name?
Well, again, Mr. Johnson is under Dr.
Do you want to tell me your name?
He's here. I've already gave you my name, ma'am. I'm his
Well,
wife.
then say it
I'm
again,
Miss
because I
Johnson.
must have missed it. What's your
Miss
name?
Johnson. Miss Johnson.
What's your first name?
Nicole.
How do you spell that, please?
Nicole.
Nicole Johnson. And you said you're his wife. Is that
That's correct. That's
You're
correct.
his legal wife. Okay. Now, if you'll let me continue, and if you won't, then we'll have to remove you from the proceedings. On August 13th, 2024, he became, as I said, argumentative, disrespectful, and interfered with the court proceedings. I found him in contempt. He was arrested, and he was to serve 24 hours in jail. And then, as I recall, the military put a hold on him, and because of whatever reasons, he served more than 24 hours. But he was told to be back here September 27. And on September 27th, there was an issue that he either was or was not receiving medical service, and he wanted a continuance, and we ultimately continued it to today. Now, that's been a month ago. And you say he's still under doctor's care and can't be here today, or is that, what were you trying to explain there?
What I was expressing, ma'am, is that he was in surgery on the day of the court date. He had
30 days
actual
ago,
surgery.
he was in surgery. Okay.
Correct. The doctor put him under doctor's orders to stay on bed rest. And that's where he's currently residing at, on bed rest. And we sent in the documentation to the courts, and the doctor notified the courts that he's not to appear because he can't travel and he can't fly due to his surgery.
And we've made it clear to him that he can appear by Zoom. So I'm going to issue a bench warrant, bond
Hold on
for
one second.